Hello guys, welcome back to the channel. I am Prakriti and today we are going to move further with Article 13 of Indian Constitution. According to Article 13, law inconsistent with or in derogation of the fundamental rights. According to Clause 1, all laws in force in the territory of India immediately before the commencement of this Constitution, in so far as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. And this clause, we are talking about the laws which are present before the commencement of the constitution, because we have adopted many of the laws and acts from the britishers period, from the britishers, such as Indian Contract Act, IPC, CRPC and many others. So the part of those acts which are inconsistent with the fundamental rights with this provision of part 3rd is to be considered as void. And according to clause 2, the state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. And according to clause 2, it is clearly mentioned that the state will not make any law that abridges the right conferred by this part, which is given by this part, means part 3rd of the Indian Constitution, and any law made in contravention of this clause to the extent of contravention be void. So one thing must have hit your mind, that what about the laws which had already been made? What are they going to be valid or not? Are they going to be enforced on us or not? So the answer is given by the doctrines. According to doctrine of eclipse, based on principle not nullity or void ab initio, but becomes only unenforceable. So by the word eclipse, it is similar to the solar or lunar eclipse, which means to overshadow that part which is inconsistent with the Indian Constitution, and it is applied to only pre-constitutional law. Let's see it with a case, that is Bhikaji versus State of MP 1955. 1947, there was a Berar Motor Vehicles Amendment Act 1947 becomes invalid in 1950 as violates Constitution Article 19(1) G, but with amendment in 1951, First Amendment, the Supreme Court held that shadow from Act removed by amendment. And according to doctrine of severability, only that part of the statute is invalid which is unconstitutional, means to that part of the act which is invalid, that is not consistent with this part of the constitution, as well as especially this part of the constitution. There are many examples of this doctrine, such as A.K. Gopalan versus State of Madras, State of Bombay versus Bhalesara 1951, RMDC versus Union of India 1957, which was for Prize Competition Act. Then Hyoto Holohan versus Jajilalu 1992, which was for, and there are many doctrines related to this article, which are doctrine of prospective overruling, which is adopted from American judicial system. It dictates that a decision made in a particular case would have operation only in the future and will not carry any retrospective effect on any past decision. That means that no any decision which is made have no prospective effect. It will be only belong to the retrospective effect. And according to doctrine of waiver, so all these rights in this part is given to the citizens, but do they have any right to waive their rights? No, they don't. According to Paseshwar Nath versus Union of India. Let's move further. According to clause 3, we are already talking about law. So what is law? In this article, unless the context otherwise requires, law include any ordinances, order, bylaw, rule, regulations, notifications, custom or usage having in the territory of India the force of law. Laws in force includes law passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all in the particular areas. According to this clause, what do you mean by law? All these consist of law, but law doesn't contain the personal law. And one thing you should notice that it doesn't contain the amendments. So whether the amendment is to be law according to this article or not, there is a long journey for this thing. Firstly, the case of Shankari Prasad, in which it was held that amendment doesn't contain in this article. So the amendment which violates the fundamental right is absolutely correct. They are not to be considered as void. It was a war between the parliament and judiciary. And then another case, that was Golak Nath versus State of Punjab 1965. In this case, it was held by the court that the amendment to be contained in this article, so the amendment not to be happen which are inconsistent with fundamental rights. Due to this judgment, the power of the parliament was decreased, and after that 24th amendment was happened in 1975, according to which clause 4 was added in article 13, which means nothing in this article shall apply to any amendment of this constitution made under article 368. The parliament tries to increase its powers, that amendment of this constitution doesn't contain under article 13. But after Keshavananda Bharati case, the things change. According to Keshavananda Bharati 1973 case, the basic structure doctrine came into existence, which means the amendment to be not to be a part of this article, but the amendments which harm the basic structure of our constitution to be challenged under the judiciary. So the judiciary have the power to safeguard our fundamental rights by saying to the amendments that whether it violates the basic structure of our constitution or not. And after that, in the case of Indira Nehru Gandhi versus Raj Narayan case, it was held that when the fundamental rights are breached by the amendment, they are to be heard by the Supreme Court. Thank you so much guys for watching this video. If you like this video, please hit the like button, and for more such videos please subscribe our channel and also hit the bell icon.